Welcome to Sakshi TV's special immigration talk show with attorney. I'm Preeti Mulbagal, your host for the show. Today we have with us for the first time Ms. Saimithra Reddy, managing attorney and founder of Mitra Law Firm based in Chicago. She studied in Northeastern University School of Law in Boston and has extensive experience working with immigrants all around the world and with the Indian population specifically on issues affecting not only the F1 and H-1B visa holders but also the detained by ICE in immigration court hearings before the immigration judges. Ms. Mitra, welcome to our show.
Thank you so much for having me. It's a pleasure.
So, Ms. Mitra, today's topic, as we know, is a very hot discussion that has created quite a buzz within the immigrants, the weighted selection process of H-1B. Shall we delve right away?
Sure, of course.
Okay. So, what are the key changes in the H-1B registration process, or what is the weighted selection process in simple terms?
Sure, that's a great question. There is a lot of misinformation out there. Some people are saying that starting next year, there is no lottery. However, the lottery is still going to be in place like it has been for every year so far. The key difference to understand is that starting next year, there are going to be different rankings given to every applicant who is trying to apply for an H-1B visa. So each applicant or beneficiary is going to be ranked as either wage level 1, 2, 3, or 4. And depending on your wage level, you get more or less entries into the H-1B lottery.
Has DHS changed how beneficiaries are selected in this lottery?
Yes, so depending on your wage level, and this is going to be mainly focused on your salary. So lower entry level positions who might be making a less salary, for example, 75K annually to 100K, they would be categorized as a lower wage level 1 or 2. Those people would get 1 or 2 entries into the H-1B lottery, as opposed to higher senior level positions who might be making more than $150,000 a year would be categorized as a higher wage level. So wage levels 3 or 4. The number of entries you get into the H-1B lottery directly correlates with what wage level you're given. So for example, a wage level 1 applicant would only be entered into the lottery one time versus a higher paid, more senior level position who is categorized as a wage level 4 would have 4 entries into the H-1B lottery. Therefore, that person would have a much higher chance of getting their name picked in the H-1B lottery. Yes.
So, are there any new employer or beneficiary attestations during the registration?
So overall, the process of the H-1B lottery, entering the lottery, getting picked, and then applying for the H-1B, and then getting your petition approved, all of those overall categories remain the same. Now, the employer, when they are sponsoring someone for an H-1B, they are the petitioner. They would have to, in detail, describe to USCIS what it is the job is, what salary they're getting, what position, and the location of the employee. So based on all of these characteristics, USCIS then gives a wage level determination for the beneficiary. So the employer just has to in detail describe what kind of position, why the salary they're saying. They're saying if a software engineer is going to get 100K salary, why is it that this level software engineer gets this salary? They have to put all of those details into the H-1B petition, and therefore, and then USCIS would be able to determine which wage level category the beneficiary falls into. So more of the, I guess, responsibility falls on the employer, and not necessarily any major changes for the beneficiary.
Okay, okay. So, are the US degrees, advanced degrees, or STEM fields weighted differently?
Not necessarily, as in previous years. Next year's lottery will also have 65,000 general applicants or slots open for anyone who has a degree and is offered an H-1B. There's always been, and there will be next year, 20,000 separate H-1B visas available for those with advanced master's degree level or higher, such as PhDs. That cap, that number isn't really going to change. And there's not necessarily a specific or special benefit for STEM degrees.
Okay. So is the weighting transparent or are the parts of selection methodology confidential?
I would say it's pretty transparent. It's not that difficult to determine your wage level. You can go online and with your employer's help, you can determine for your position, where you live, what salary range you should be given. The Department of Labor is pretty transparent about giving a certain wage level, which is called the prevailing wage for each type of career, right? So depending on your job specifically and where you live, you would be given a certain wage. It's quite transparent how they're planning to do the lottery next year.
Understood. So what prompted DHS to introduce this new H-1B process and what problems is it trying to fix?
Sure. So in the DHS regulation about this weighted selection process, they actually openly state the reason for why they are proposing these new changes. Um, it's mainly to combat H-1B fraud and the abuse of the H-1B visa. Congress, the entity that is in charge of creating immigration rules and regulations, has found that there has been a wide-scale abuse of the H-1B system. From multiple entries or maybe fake job postings, and entering people into the lottery who don't actually have a job. So those are some of the H-1B abuses and frauds that they are trying to combat. The H-1B program has always been meant for and was created for highly skilled and highly paid workers. So by doing this, the Department of Homeland Security is really trying to prioritize high skilled and high paid employees and professionals.
They're filtering out, they only want the cream.
Yeah, the best of the best who really should be here to fill the positions in these very specialized knowledge positions that US workers and people who are born and raised here, they cannot fill those positions. So that's why they're going out to other countries and getting workers from abroad.
So how does the beneficiary-centric system then handle multiple registrations for the same individual?
Sure. So you can still have multiple jobs offered to you, right? You can still have multiple employers who are sponsoring you for an H-1B visa. So say I am a candidate for the H-1B and I get a job from Amazon, Google, and Microsoft. That would be the dream, wouldn't it? But all three companies can absolutely sponsor me and enter me into the lottery. However, it's not that I get three chances. I actually just get my name entered in once. Each individual person is tied to data such as your date of birth, your social security number, your passport number. So you can't get three different entries into the lottery. You can get one entry, but you can have multiple job offers. And actually, the lowest of the wages is the one that they're going to use to determine the wage level. So if you have a 150K offer, 125K offer, 100K offer, the lowest 100K offer is what they would determine your wage level by.
Wow, wow. So they need to be very careful on when they are getting their name applied by
Yes.
their employers.
Yes, absolutely. Yes. Trying to trick the system and enter multiple times is just not going to
Right, they're making
happen.
it completely foolproof.
Yes, as much as possible, right?
Because multiple job offers, usually we tend to understand that that will improve the beneficiary's chances, but it
Yes.
doesn't seem
Now
so.
that is no longer an option. No matter how many job offers you have or how many employers who are willing to sponsor your H-1B visa, you only get one entry depending on your wage level. You could get a second entry depending on if you have a higher wage level. Now it's really just depending on how much you make. Are you a senior position? Are you an entry level position? So that's what's going to determine the possibility of you getting an H-1B visa rather than do I have five different job offers and five different entries.
Okay. So what safeguards exist to prevent gaming or any collusion of employers by employers?
Sure. So I think we can start with looking at the employer requirement. I was talking about that briefly earlier, how employers now have to list in detail what exactly the job is, what the requirements of the job are, the beneficiary who they are sponsoring for the H-1B visa, what their educational qualifications are, and why they should be categorized as not only a specialty occupation, but how did their qualifications meet the requirements for this job? If an employer tries to categorize someone as a senior software engineer, you have to describe why exactly this beneficiary should be categorized as a senior software engineer. Do they have 10 years of experience? Do they have a PhD? Right? So employers have to describe in detail why someone should be categorized as a higher wage level. I think that's one way that USCIS can really weed out who's trying to game the system, like you said. In addition, you can try to put a fake salary, right? Say that maybe a 100K position, you can say, oh, we're going to pay them 200K. However, USCIS and our office has already been seeing this, especially in this administration, is being very strict about H-1B registrations and H-1B visas in general. So even after an applicant has been picked in the lottery and their H-1B has been approved, you can still receive a request for additional evidence, a notice of intent to revoke, meaning USCIS can reopen an approved H-1B visa and then look into it. If they see or suspect any fraud, they can revoke the approved visa. So the scrutiny is quite high for H-1Bs generally, even after it's been picked in the lottery and even after the petition has been approved. So I think those are some of the safeguards or some of the mechanisms USCIS is using to stop any kind of H-1B abuse or fraud.
Wow, very nice. So, can an employer withdraw or modify a registration after submission?
Yes, absolutely. It's been common what's happened up till now and moving forward. Employers can absolutely withdraw any H-1B sponsorship at any time. In terms of modifying a petition, that is a bit more difficult. You can't, at the time of filing the H-1B petition for a beneficiary, say that this person is an entry-level 100K salary person, and then 6 months later say, oh, just kidding, they're not. Modifying is a little bit more difficult. However, an employer can always at any time withdraw a petition.
So, are these changes statutory, regulatory, or policy based, and how permanent are they?
So they're definitely regulatory. This is DHS, the Department of Homeland Security, that is implementing this regulation. The H-1B regulations, as it stands, are still very much in place. The major criteria for being eligible for an H-1B petition, all of those are still the same. DHS is now implementing new regulation to modify the existing process, so they are not overhauling the entire system. Speaking of how permanent are they can be modified again. It would just have to go through another proposal that DHS puts out. The public can comment on it, and then they can finalize the rule. But it would take some time, maybe 6 months, 1 year. However, it's not so permanent. It can always be modified or changed.
How should the employers adjust salary offers in light of the weighted system?
Sure. I think they need to really determine, based on the person's experience, based on the complexity of the job, what the job really requires, whether it is a specialty occupation or anyone with a bachelor's degree or a lower degree can do this. They should look at the location as well. Of course, a software developer in New York City or LA, which are both very expensive cities, would need to have a higher salary than someone maybe living in Dallas, Texas. So they should be looking at the locality, the complexity of the job, the background of the employee, and how rare is it to actually find someone to fill that position who is a US citizen or a legal permanent resident. So they should take all those factors into consideration and make sure the wage actually matches that. If they try to buffer up the wage and make it a higher wage so that their beneficiary has a higher chance of getting selected in the lottery, that could be seen as H-1B fraud or trying to game the system.
So, does this disadvantage startups or smaller employers with low wage structures?
Absolutely, because the lottery is solely going to be based on a wage level determination. Startups, nonprofit organizations, smaller companies who cannot afford to pay their employees on a scale of a big corporate company will definitely be at a disadvantage. I do think that there are going to be a lot of negative implications for smaller companies, startups, and especially nonprofit organizations.
So in that case, the consulting and staffing companies are also negatively affected, right?
Yes, I would definitely say so. Consulting companies who are not paying 150, 200, 250K, they would not be able to keep up. They're going to have less people who are going to be selected in the H-1B lottery who they can employ. There will be a negative effect.
Okay, okay. So what documentation should employers prepare to justify the wage levels?
Okay, so employers should definitely put forth in terms of what documentation from the beneficiary, their degree. So, do they have a bachelor's degree? Do they have a master's degree? What level of education they have? What qualifications they have? Do they have additional certification? Do they have additional job experience, work experience? So, the background and the educational qualifications of the employee. In terms of the employer, information about the job, like we discussed before, right? What is this job? What is the complexity of the job? Who is needed to fill this job? What is the salary that usually people in this kind of job get? So documentation about that. They should, as has been standard, definitely put forth the SOC code, which is just an occupational code that says what exactly the career is. Are you a software developer? Are you an electrical engineer? So there is a code that aligns with that. They should also put forth the OEWS, which is the Occupational Employment and Wage Statistics. That, without getting too technical, I don't want to lose people, that basically determines everything we've been talking about, the background and the educational qualifications of the employee and the complexity of the job to determine what is the wage that this employee should get. So they should put forth all of that information when filing the H-1B petition.
Okay, okay. So what new compliance requirements do employers need to be aware of in this case?
Sure. So that's kind of what we just spoke about. Compliance requirements are very similar to what has been in place before. They are getting into the right wage level determination, and they're not putting their beneficiaries or employees in the wrong wage level determination, thus giving them an advantage. Mhm.
So that's the major compliance norm that they need to be aware of.
Yeah,
Need to,
yeah. In
to be.
terms Right, right. In terms of additional documentation or additional requirements, there's not that much of a difference from what they were required to do beforehand.
Okay, okay. So how should the F1 students and the OPT holders plan under the new system?
That's a really great question, and that is something that a lot of F1 students are worried about. Of course, as a recent graduate, it's very difficult to get a very high-paying position right after finishing your master's degree. I think F1 students, one, really need to focus on getting internships while they are in their study period and getting a job right after graduating, instead of maybe joining a consultancy and waiting to see if they can get placed in a project. They should prioritize getting a job right after graduating. I would say if you are already working, there is an option for master's students, F1 students, to work through CPT. Maybe try to get a promotion, maybe try to upskill yourself. It's not going to be easy. Unfortunately, the reality is that this is really making it more difficult for recent grads and entry-level workers to get selected for the H-1B visa. It's really prioritizing people who are already in the workforce, who are already in more senior positions, who already have years of experience. That really puts F1 students at a disadvantage. So if you already have an internship or a job, try to get into more certifications, trainings, and try to get a promotion so you can get into a higher wage level determination. If not, then network, really focus on your career and try to have a job right after graduation.
So how closely is DHS scrutinizing wage levels listed in the LCA?
That is a good question. We won't really know, right, until it is implemented. This is a proposed rule. It is a final rule, and it'll go into effect next year for the next H-1B lottery. My take on this after reading the DHS regulation is that they will be really closely looking at it. The whole purpose of this regulation is to combat H-1B fraud and abuse of the system, right? So they are going to look at specifically what the position is, why the justification for someone being in a wage level 1 versus wage level 3. So they're going to be looking at it closely. As I mentioned before, generally the H-1B visa has been highly scrutinized under the Trump administration. So I do believe that DHS is going to very closely look at why each individual applicant who is selected in the lottery or who's trying to enter the lottery has been categorized in a certain wage level or not. I think there will be pretty high scrutiny.
Okay. So, what are the risks of inflating wages just to improve lottery chances? So, we did speak about
Yeah.
what issues are, how it is dangerous to inflate the lottery chances and to inflate the wages. But then, what are the actual risks? What happens?
One, there might be repercussions for the employer. So employers who are found to be in violation of immigration rules and regulations by inflating a beneficiary's proposed wage level or the salary, if they are found in violation, for example, if it is a consultancy, then that consultancy could be fined. They could be blacklisted. They could be shut down. It would be a violation of immigration law, which is a US federal law. For beneficiaries, the most obvious, I guess, negative outcome is that their H-1B petition would be denied. However, like I mentioned before, even after the H-1B petition is approved, if DHS has any reason to believe that there was some sort of inflation of the wage level, solely for the purpose of getting more entries into the lottery, then even an approved H-1B petition can be reopened and revoked. At a minimum, you can receive a request for evidence, an RFE, but more serious than that, you can get a notice of intent to revoke where an approved petition is reopened and it can be revoked. So they would lose their H-1B visa, they would lose their status.
So, what mistakes should the beneficiaries avoid while relying on wage-based system?
I think in terms of what mistakes should be avoided, there shouldn't be really employment fraud, trying to say that you are qualified for a certain job when you're not, applying for jobs that you really are qualified for, that matches your educational background, that matches your technical skills. So if you have a fake person taking your interview, if you get into a job that you're not qualified for, I think that puts the beneficiary or the employee at risk of being caught and being determined that you actually shouldn't be getting this salary or be given this kind of wage level determination. So they should try to just be honest and apply for the jobs that they are qualified for and that they can actually sustain.
Understood. Understood. So, are there any alternative visa strategies employers should consider now?
That's a really good question. The H-1B visa has traditionally been the most common visa for especially Indians who are pursuing more traditional STEM careers because that directly leads into highly skilled positions such as engineers or software engineers, software developers, those kinds of positions. In terms of other options, the O1 visa is something that employers definitely can be looking at. And not only employers, but beneficiaries. So the employees or the potential candidates who are trying to apply for the H-1B visa, if they are not able to get picked in the H-1B lottery, then the O1 visa is a very good alternative. It is a visa for people with extraordinary talent. So if you have any kind of research background, if you've made any publications, if you have any work experience, if you can show that you are someone of extraordinary talent, then you can apply for that. You don't even need an employer to sponsor you. So that is something you can self-sponsor yourself for and would give you work authorization and the ability to work here in the United States.
So before we close, Ms. Mitra,
Sure.
could this system eventually replace the lottery entirely?
It could. I don't know how soon that would happen. I don't anticipate such a big overhaul of the existing system happening next year or even the year after. I think there has to be some major immigration reform for that to happen. I do anticipate some pushback actually on this rule itself. So next year is the first time we're going to see such a different approach to the lottery. And I do anticipate some sort of pushback or some sort of legal challenges, specifically for people who are employed in nonprofit spaces or startup companies. Like we discussed earlier, it will really have a negative impact on nonprofit organizations or startup companies. It will really disadvantage people from doing that kind of essential work. I can imagine in the future that there might be an exception for someone who is employed at a nonprofit organization, an NGO, maybe doctors, people who are doing work in the national interest of the United States. There might be an exception for those kinds of people. So I think there will be some sort of pushback. I don't believe that the whole system will be rehauled. The lottery is going to completely go away. However, as we've seen so far in the Trump administration, I think anything is possible. Things are
Anything is
changing every
possible.
day. Right, things are changing every day, so we're just going to have to wait and see. But for next year, I don't think there's going to be any more major H-1B related lottery changes.
So next year's major changes are being seen from right now itself.
From
So
from now, exactly. Yeah, yeah. Hopefully no more major changes before next year's lottery.
yeah, let's hope. Let's keep our fingers crossed. And thank you so much, Ms. Mitra. You've provided our audience with very valuable insights and amazing information on the newly awaited H-1B process selection system. Thank you so much. You have a great day.
Thank you so much for
See you
giving
next
me
week.
this opportunity. See you. Thank you.